as conversely Pinckney wished Congress to be given explicitly the power to nullify state legislation, and Marshall, very sensibly, pointed out that, were Jefferson's claim carried into practice, it would create "a hydra in government." Yet I am confident that Marshall did not appreciate whither his own assertion of authority must lead. In view of the victory of centralization in the Civil War, I will agree that the Supreme Court might have successfully maintained a position as arbitrator touching conflicting jurisdictions as between the nation and the states, but that is a different matter from assuming to examine into the wisdom of the legislation itself. The one function might, possibly, pass by courtesy as judicial, the other is clearly legislative. This distinction only developed after Marshall's death, but the resentment which impelled Marshall to annul an act of Congress was roused by the political conflict which preceded the election of 1800, in which Marshall took a chief part. Apparently he could not resist the temptation of measuring himself with his old adversary, especially as he seems to have thought that he could discredit that adversary without giving him an opportunity to retaliate. In 1798 a Federalist Congress passed the Alien and Sedition Acts, which constitutionality no Federalist judge ever doubted, but which Jefferson considered as clearly a violation of the fundamental compact, since they tended to drive certain states, as he thought, into "revolution and blood." Under this provocation Jefferson proclaimed that it was both the right and the duty of any state which felt itself aggrieved to intervene to arrest "the progress of the evil" within her territory by declining to execute or by "nullifying" the objectionable statutes. As Jefferson wrote the Kentucky resolutions in 1798 and was elected president in 1800, the people at least appeared to have sustained him in his exposition of the Constitution before he entered into office. At this distance of time we find it hard to realize what the election of 1800 seemed to portend to those who participated therein. Mr. Jefferson always described it as amounting to a revolution as profound as, if less bloody than, the Revolution of 1776, and though we may be disposed to imagine that Jefferson valued his own advent to power at its full worth, it must be admitted that his enemies regarded it almost as seriously. Nor were they without some justification, for Jefferson certainly represented the parties of disintegration. Nullification would have been tantamount to a return to the condition of the Confederation. Besides, Jefferson not so many years before had written, in defense of Shays's rebellion, that the tree of liberty could never flourish unless refreshed, occasionally, with the blood of patriots and tyrants. To most Federalists Jefferson seemed a bloodthirsty demagogue. In 1796 Oliver Ellsworth had been appointed Chief Justice by General Washington in the place of Jay, who resigned, and in 1799 John Adams sent Ellsworth as an envoy to France to try to negotiate a treaty which should re-establish peace between the two countries. Ellsworth succeeded in his mission, but the hardships of his journey injured his health, and he in turn resigned in the autumn of 1800. Then Adams offered the Chief Justiceship to Jay, but Jay would not return to office, and after this the President selected his Secretary of State, John Marshall, one of the greatest of the great Virginians, but one of Jefferson's most irreconcilable enemies. Perhaps at no moment in his life did John Adams demonstrate his legal genius more convincingly than in this remarkable nomination. Yet it must be conceded that, in making John Marshall Chief Justice, John Adams deliberately chose the man whom, of all his countrymen, he thought to be the most formidable champion of those views which he himself entertained, and which he conceived that he had been elected president to advance. Nor was John Adams deceived. For 34 years John Marshall labored ceaselessly to counteract Jefferson's constitutional principles, while Jefferson always denounced the political partiality of the federal courts, and above all the rancorous hatred which Marshall bears to the government of his country, and the cunning and sophistry within which he is able to enshroud himself." End quote. No one at this day would be disposed to dispute that the Constitution, as a device to postpone war among the states, at least for a period, was successful, and that, as I have already pointed out, during the tentative interval which extended until Appomattox, the Supreme Court served perhaps as well, in ordinary times, as an arbiter between the states and the general government as any which could have been suggested. So much may be conceded, and yet it remains true, as the record will show, that when it passed this point and entered into factional strife, the Supreme Court somewhat lamentably failed, probably injuring itself and popular respect for law far more by its errors than it aided the Union by its political adjudications. Although John Marshall, by common consent, ranks as one of the greatest and purest of Americans, yet even Marshall had human weaknesses, one of which was a really unreasonable antipathy to Thomas Jefferson, an antipathy which I surmise must, when Jefferson was inaugurated, have verged upon contempt. At least Marshall did what cautious men seldom do when they respect an adversary. He took the first opportunity to pick a quarrel with a man who had the advantage of him in position. In the last days of his presidency, John Adams appointed one William Marbury a justice of the peace for the District of Columbia. The Senate confirmed the appointment and the President signed, and John Marshall, as Secretary of State, sealed Marbury's commissions. But in the hurry of surrendering office the commission was not delivered, and Jefferson found it in the State Department when he took possession. Resenting violently these "midnight" appointments, as he called them, Jefferson directed Mr. Madison, his Secretary of State, to withhold the commission, and, at the next December term of the Supreme Court, Marbury moved for a rule to Madison to show cause why he should not be commanded to deliver to the plaintiff the property to which Marbury pretended to be entitled. Of course, Jefferson declined to appear before Marshall through his Secretary of State, and finally, in February, 1803, Marshall gave judgment in what was, without any doubt, the most anomalous opinion he ever delivered, in that it violated all judicial conventions, for apparently no object save to humiliate a political opponent. Marshall had no intention of commanding Madison to surrender the commission to Marbury. He was too adroit a politician for that. Marshall knew that he could not compel Jefferson to obey such a writ against his will, and that in issuing the order he would only bring himself and his court into contempt. What he seems to have wished to do was to give Jefferson a lesson in deportment. Accordingly, instead of dismissing Marbury's suit upon any convenient pretext, as according to legal etiquette he should have done if he had made up his mind to decide against the plaintiff, and yet thought it inexpedient to explain his view of the law, he began his opinion with a long and extrajudicial homily, first on Marbury's title to ownership in the commission, and then on civil liberty. Having affirmed that Marbury's right to his office vested when the President had signed, and the Secretary of State had sealed the instrument, he pointed out that withholding the property thus vested was a violation of civil rights which could be examined in a court of justice. Were it otherwise, the Chief Justice insisted, the government of the United States could not be termed a government of laws and not of men. All this elaborate introduction was in the nature of a solemn lecture by the Chief Justice of the Supreme Court to the President of the United States upon his faulty discharge of his official duties. Having eased his mind on this head, Marshall went on, very dexterously indeed, but also very palpably, to elude the consequences of his temerity. He continued, "The right of property being established, and the violation of that right clear, it is plain that a wrong has been committed, and it only remains to determine whether that wrong can be redressed under this form of procedure. We are of opinion that it cannot, because Congress has no constitutional power to confer upon the Supreme Court original jurisdiction in this class of litigation. In the lower courts alone can the relief prayed for be obtained." of all the events of martial